presentation. My name is Ryan Tan, and today we're going to be going through Startup Fundraising 101. This is a topic that is very common and very popular amongst our legal advice plan users, but for all small businesses as well, because no matter what stage you're at in the journey, you're likely to go on and raise some investment, whether it's from family and friends, or whether you're looking to scale it large and get venture capital funding, or even simply put in place an employee share option plan, then this is a phenomenal webinar to get some value from. So again, stay tuned throughout the webinar as we do cover capital raising and the process as well. I'm going to launch a poll here. Just take a moment to fill out this poll with some information about what your company's biggest focus is in 2022, and then what industry you're in, and then a few other questions on the age of your business. This does help us tailor the content of the webinar to be more specific to small businesses like yours. And again, if you do have any questions from today's webinar, please pop them in the chat or the Q&A box. And at the end, we'll be doing a Q&A with Damon. Now, for everyone on today's webinar, we will have an exclusive webinar offer. Again, we do try and mix these up. So today's webinar offer is not one that we've presented before. So if you're in need of any startup fundraising advice, raising capital, or you need some help around positioning employee share option plans, then stick right through the presentation to the end for the exclusive webinar offer available for everyone here today. And then Damon will take some questions and answers at the end as well. So just jumping into today's agenda, we're going to be going through a bit about law path, and then we'll go straight into the presentation on capital raising, everything there is to know about capital raising. So what process to use, what documents, you might have some on the law path platform, like a SAFE agreement. So David will go through both documents, the pros and cons, and best practices in approaching the capital raising process. And then again, stick towards the end, we will have a Q&A time where you can answer questions. So thank you to everyone who is keying in your names and questions in the chat as well. So just a bit about LawPath to get the presentation started. What we provide is smart, simple legal for small businesses. And we do this through our contract management system, where we have over 380 legal templates built into the platform that help you create legally binding legal documents, as well as having a full suite of contract management features such as e-signature and the ability to add teammates into your account. Now, through the platform, you're able to achieve an end-to-end solution where you can not only create these documents, but you can sign them and store them securely through our platform. So that's one side of what we offer. And the other side is offering on-demand legal advice, where you can get unlimited 30-minute calls with our lawyers and accountants on new topics as well. So like the slides say, you can create legal documents, manage compliance, and connect with lawyers on demand in one single platform. And over the last 7 or 8 years in operation, we've assisted over 300,000 small businesses, saving them over $100 million in legal fees. And we've garnered over 10,000 5-star reviews on Trustpilot, and we're only just getting started. So if you're a small business, no matter what industry or sector you're in, we're bound to have documents that can help you put your compliance in place and then get advice, both from a legal and accounting standpoint as you do scale up the business. So we'll get into today's presentation. I will introduce you to Damon. Now, Damon's no stranger for anyone who's attended past webinars, or you're on a legal advice plan and you've booked in some consultations. He brings over 14 years experience in an array of legal areas. And this is one topic that he's extremely passionate about, on raising capital. So without further ado, I'll pass it over to Damon to kick off today's presentation.
Thanks, Ryan. Damon here. So this is everybody's favorite topic, raising money and how do you do it. So I'll go through all the different documents that you've probably heard of, a little bit of information that's going to be valuable for raising capital, and then get into your questions at the end. So to begin with, pre-investment stage. So let me this is a very brief note on pre-investment. One of the things that we come across normally as the main hurdle when you're doing a capital raise is proving that you actually own everything that you're trying to sell, in the sense that you might be wanting to sell shares in your business. You say you have this great technology. Well, the first thing an investor is going to do is have a look at whether you own the IP. So if you've ever hired someone to do your logo, hired a software developer overseas to develop your technology for you, they're going to look into the contracts that you might have. So do you own the IP? Has the IP been assigned to you? Do you have a software development agreement that says that that IP is yours? And if not, then at the time the investor comes and starts doing their due diligence, they're going to ask you to do one of two things. One is get a contract signed off from the person that created that IP, making sure that you own it. Or two, the founder is going to have to give a personal guarantee in many respects in terms of a warranty where the founder is saying, I promise that all this intellectual property is owned by us. And if for whatever reason it's not, then you can take some of my shares away as I'm going to bear the liability for not having my own financials in order and contracts in order. So at the pre-investment stage, it's always important that you do a couple things. One is make sure you have a shareholders agreement, constitution, if you have board meetings, make sure you have those in a nice folder. If you've issued shares, make sure you have a contract to reflect that. Share certificates as well. Your member register, which is who's a shareholder, when do they become a shareholder, how many shares do they have, how much do they pay for that? And then also starting to get your cap table together, which I'll talk to you about later. But if you're still starting out, you're still new, you have some contractors, you have some people doing work for you who are not employees, make sure you have a contract with everybody assigning the IP to you so that you don't have this hurdle when it comes time raising capital later. Now, there's a difference between a public company and a private company. Most of you will be a private company. Public companies have special rules when it comes to raising capital. That's because they're highly regulated. Normally they're listed on the ASX, or alternatively, they're an unlisted public company. But again, their financials are in the public domain. They have to submit them to ASIC every year. And most of the times they have to do announcements when it comes to a public company, and you can do a search of all their financial reports. So the requirement for raising capital for them isn't necessarily as strict for a private company. Now, when you have to become a public company once you exceed 50 employees. So that's another thing, or 50 shareholders. So that's another thing to consider, that if you're going to do a cap raise, you don't want to be raising capital where everybody can put $500 in or $1,000 in that turns into 25 shareholders, because you are moving closer to having to convert into a public company. So you normally want to put a minimum amount of money that people have to invest. So you get larger investors, but less number of investors. And that's just so that you don't hit that 50 number or that 50 threshold. Now, if you do hit that 50 threshold, what that means is that you have to convert into a public company. And if you have to convert into a public company, you have to have 3 directors, you have to have an auditor, and the cost of maintaining your company is significantly higher than just being a private company. Now, as a private company, you're not allowed to advertise the fact that you're raising capital. You can't post something on Facebook. You can't post something in Google AdWords saying I'm selling shares in my business, because the selling shares in your business is a security, or it's a financial product. And then you would be possibly giving financial advice on that product that you're selling. And that's regulated under the ASIC Act. And so what that means is that you're prohibited under the Corporations Act from offering shares in the public domain. And what that means also is that you're limited to a certain group of people that you're allowed to advertise to or market to. And those are only the people that you really do know. So those exemptions, you probably heard of the 22 rule, or you might have heard of it. And that comes under section 708 of the Corporations Act. And it says that a private company can raise money by way of an investment into their company, up to 20 investors for every 12 months and up to $2 million. Now, they can only get that money from a personal offer, which is someone that they know. So a direct connection with that person. So it might be a senior employee that you have, or it might be, you might know a broker at Bell Potter who's a professional stockbroker, and they have some people that they know who would be interested in investing in your company, and that's the professional connection exemption as well. So Section 708 is very technical. You got to be very careful if you're going to be disclosing the fact that you're investing to third parties. Now, the other exemption is also under Section 708, and that is sophisticated investors. And that's someone that makes more than $250,000 a year, has more than $2.5 million worth of assets, and has a certificate from an accountant. And so what that means is that you can go to sophisticated investors. So you might have Sydney Angels or Melbourne Angels or Brisbane Angels, or not to give these guys a plug, but Wholesale Investor has a big database of sophisticated investors, and they're the ones that are exempt from having to get what's called a disclosure document, which is like a prospectus. And you don't necessarily need an AFSL license to give advice on a financial product or financial service, because they don't necessarily have the protections that your mom and dad investor does have under the Corporations Act. So sophisticated investors, you are allowed to approach them, and Wholesale Investor has a special order that allows them to introduce startups to a sophisticated investor. And there's also incubators and accelerators and VCs and so on, and they're all sophisticated investors, and you can take money from them, and the 20 investor $2 million threshold doesn't apply to them either, neither does the disclosure requirement. So that's normally how people find capital. So if you're a private company, the way is friends and family, a professional connection. So it might be a professional capital raiser who's going to go and has a AFSL license, who's going to go and market your product for you to sophisticated investors, a platform like Wholesale Investor, or the other one is crowdfunding. And crowdfunding also is allowed and it's permitted. And the number of investors that come into the crowdfunding, those crowdfunders don't count towards the 50 shareholders. So if you were to go over that 50 mark by way of a crowdfund through a licensed provider, then you're not going to have to worry about that 50 shareholder threshold to switch to public companies, because those shareholders don't count towards the 50 shareholder. Now, when you look at disclosure companies for private or for public companies, which kind of also apply to public or private companies as well, is that a public company will raise money by a prospectus or a profile statement, information statement, things like that. That's because they're highly regulated. If you were to advertise or market your shares to the public generally, then you'll generally also need a prospectus. And so most people want to avoid having to prepare a prospectus, because the cost to prepare it is very expensive. So normally that's why you go to the sophisticated investors. Now, let's look at how most people decide on what kind of method to raise capital. So the first thing you look at is, well, how much money have you actually spent so far in growing your business? So are you a software developer yourself and you've been sitting in your home developing for the last year, and you've applied for R&D tax grants, and you can prove that the value of your assets worth 300 grand based on the time that you've spent to build it? Or are you just starting a marketplace, you haven't put a lot of capital into it, and therefore you don't have any evidence of the value of your assets? Have you received external capital from anyone? Is it a big name? Is it somebody who has seen a vision of what you're offering? If you've received capital already, then you might be able to leverage off of that. And how you've spent that money. So it might be that you've raised that money already and you're able to show an investor what you've done with that money. So you might have had a minimum viable product. You might have taken in $250,000, and then you've now developed it. And now you're going out for a new raise to market your product, and you need the capital to get it to market. Now, if you can show that you use that money specifically to develop it, then again, that might mean that you have other methods to bring in resources and finances. And then whether you actually are pre-revenue, post-revenue, early stage revenue, whether you have any contracts in place on trials or pilot programs with anyone, a letter of intent often says, I will buy into your business if you can prove to me that you have this many users, or I have a letter of intent from this big blue chip company, but they're not going to do business with me until I raise this capital or add this feature to my product or whatever it is. So it really does depend on where you are, but we'll have a look at, generally speaking, if you fit into certain molds, and it's normally the kind of investment you're going to be taking in. So the first one is pre-revenue. You can't really prove that you've necessarily developed anything, or you can't prove that you have huge stock limits or anything like that, whether you're selling a product. You might not be able to show a lot of users, but you do have your minimum viable product. In this case, it's going to be very difficult to find an external investor. You can try to pitch to an external investor. You might not have a lot of success. And in those circumstances, you're normally going to be going to your friends and family. And if you go into your friends and family, oftentimes you're using the agreement called a simple agreement for future equity. And that's essentially not putting a valuation necessarily on your business. And I'll talk more details about what we call a safe note. The next one is, if you are still pre-revenue, but you can show that you have put a lot of resources in, might have been your own money, might have been your own time. You maybe have a lot of users, but they're on a free trial. It might be that you have a lot of really good business connections already. People have signed off on contracts, but you haven't delivered yet. In those cases, you might be actually going into more of a convertible note, or maybe the sale of your shares. But again, I'll talk about those documents in the next slides. And then the next one is your post-revenue. You're making money, you're looking to grow, you're looking to take in more capital to hire your sales development manager or whatever it is, improve your technology. And in that case, oftentimes you're going to be actually selling shares in your business. Or you could look into debt. And debt's not terrible. It's actually sometimes good. I know a lot of people say, you know, I don't want to raise capital by way of debt, but sometimes debt is the smarter way to do it. And I'll talk about that as well. So before I do, let's just talk about cap table. Everybody hears about the word cap table, what it is. It's essentially just Excel spreadsheets. So just imagine you have an Excel spreadsheet. It shows you as holding 100 shares, your other founder holding 100 shares, total amount of shares 200. That's the beginning of your cap table. The next step would be then it shows you and your co-founder each holding 50% of your company, because you each have 100 over 200 shares. The next part of your cap table would be, well, what does it look like if I brought in an investor? And that would be, I'm selling 20% of my business, or let's just say for simple numbers, 33% of the business. So in that case, the next line over, or the next columns over, you would show you holding 100 shares, your co-founder holding 100 shares, the investor coming in, who you might not know who it is, also holding 100 shares. Now you have 300 shares, and each of you have 33%, rather than you and your co-founder holding 50%, because now you have 1 divided by 300. So you've been diluted down from 50% shareholding to 33% shareholding, because you've issued another 100 shares. So that's just what a cap table is. If you hear about it, just Google it. You can get some templates online of what they look like. And it's basically gives you a good idea of what your share percentage will look like after you raise your capital. And to do that, you want to say, well, how much money do I need? And you'd never want to take in necessarily more than what you actually need. So you might say, I need $2 million. But the question is, well, what do you need that $2 million for? Well, I need $500,000 to improve my business, however it might be. Normally, it's building up your technology. Well, then maybe you want to just raise the $500,000 right now, because once you raise that, then you can go back to market and raise 1.5 million at a higher valuation, showing that you actually have a product, rather than raising 2 million now without that final product. So you normally don't want to raise more than you need, because that means that you're going to be diluting yourself down at a lower valuation. So going back to that example, you and your co-founder each have 100 shares, you're offering your new investor 33% of the business. You could value your business now at 2 million, but later on you might be able to do it at 5 million. And rather than giving away 33% of the business, maybe you're only giving away 20% of your business, so you don't get diluted down as much. So just have a consideration for that as well. Now, what is a simple agreement for future equity? High level is, I have no idea what my business is valued at right now. I've kind of just started out. I don't have that market share that I thought I would have. I've built the technology, but I haven't got a lot of traction. I need money for Google AdWords, Facebook marketing. I need an influencer to build it for me as well. And maybe I need to get an employee to come on and help grow the business. Well, in that case, the question is, well, do you want to value your business right now? It might be that you don't want to undervalue it. You might say, right now, all I have is this $100,000 website. So I'll just value it at $500,000. Well, you might be underselling yourself, because after you take in $250,000, you might grow it very fast, and it might be worth $3 million within a couple months. And now you've just given all these people essentially shares in the business at a fixed valuation. And so what a SAFE does is it normally doesn't fix the valuation. It says, I will take your money now. So let's say I'll take $100,000 now, and I will give you shares in the future, maybe 24 months from now, which is the maturity date. Or I will give you shares when we do a next capital raise. And so I don't know how many shares I'm going to give you, because I'm going to give you shares when the next investors come in, and I'll give you a 20% discount to what the next investors pay. So for instance, someone gives you shares now at 100,000. You don't know what the value of the business is. In a year from now, someone comes and invests in your business at $1 million valuation. You then issue shares to your SAFE investors of the $100,000 investment. You now issue shares to them at an $800,000 valuation rather than the $1 million valuation, because they get a 20% discount to investing early. The problem with the SAFE note is a lot of investors aren't liking it that much, because they don't get any rights. They don't get voting rights. They don't get rights to buy shares in the next round. They don't get rights to the books and records of the company. They don't get dividends. They're not a shareholder, so they don't have legal rights under the Corporations Act. All they have is a contractual promise that you will issue them shares in the future. And then the question is, well, what happens if you don't raise capital in 24 months from now? Well, a lot of the standard templates have been drafted that just makes the assumption that a startup will, and then it's causing a lot of disputes. So you should have clauses built into a SAFE that says, well, if I don't raise I don't do another capital raise in 2 years from now, then I will automatically convert you at the fair market value. And you have a formula of how that's calculated. It might be based on your revenue, might be based on your accountant or a third-party accountant valuing your business, or you can then set a valuation cap and say, well, if I don't raise any capital, the business isn't doing that great, so I'll value it really low in 2 years from now at this value, and I'll give you your shares there. So that's what a SAFE's used for: friends and family, early stage generally. The next one's a convertible note. A lot of times this is the most favorable document to an investor, because what it says is, I will invest $100,000 in your business right now, and I get to choose on the maturity date of 24 months from now whether I convert my investment into shares or get my money back plus interest. And the danger to a startup is this, is that if someone gives you $100,000 now, you spend that money, in 2 years from now, the investor doesn't like where the company is at and says, I want my $100,000 back. Well, you might not be able to pay it back, which means now the company is committed an act of insolvency, because it becomes due and payable on the maturity date. You can't pay it back. So the only way that you can then pay it back is normally by raising money from another investor. and you might not be able to get a loan because you might not have the financial track record to get a loan. So you have to raise money from another investor to pay out the original convertible note holder. And the problem you have with that is that a lot of investors don't want to put money into your company to pay out a debt. They want to put money into your company to grow it. So you then have to explain to a future investor, well, this investor came in, they want their money back, but they don't want the money back because they're not doing very good with my business. They want their money back because their circumstances changed or something, and you got to somehow convince a future investor to put their money in, and it puts you in a very precarious position. So we normally try to steer away from convertible notes when we act for startups because they can be very dangerous in that regards. Whereas for an investor, it gives them the perfect opportunity to choose later what they want to do. And then the last one is actually issuing shares. And that, well, I'll talk to you about in a moment. So going back to that, the convertible note, very similar to a SAFE. It says that we'll give you money now. We get to choose in 2 years whether we get the money back or whether we convert, and how many shares we get when we do convert. It's normally based on the next equity round and what other investors have come in at, or it's based on some formula or the fair market value, or it's set in the convertible note and says how many shares they'll get. The difference between a convertible note and a SAFE is that in a SAFE, the investor doesn't get their money back. That's guaranteed money in the bank. They don't get their money back, they just get shares. Whereas convertible note, the investor gets to choose which one, and that's why it creates that risk for you. Now, the next one is allocating new shares. Oftentimes people will go and they'll create a company and they'll issue themselves 1 million shares. The problem with that when they created their company is they issued 1 million shares for $1 per share. And their intention is that they'll sell their shares or transfer their shares to a new investor in the future. If you've done that, you've got to immediately fix your share registry and fix that, because a company that's a proprietary limited company, a PTY LTD company, it means that the shareholders are liable only to the amount that they paid for their shares. So if you created a company for $1 million with $1 per share, that means you owe the company $1 million. And if you have to liquidate your business, that liquidator will sue you for $1 million. Now, the other ways to do it is you can create your company with 1 million shares, with each share value is 0.00001, and then it's around $100 or $10 or $1,000 paid up capital, and that's okay. But you don't want to be valuing your shares at $1 million. That's the first mistake. The second mistake is you're never transferring your shares to somebody. Very, very rarely, because your new investor who's coming in, what they're doing is they're investing into your company. So they're buying shares off of the company. So the company issues new shares. They pay the company money into the bank. And now the company has sold the shares. But if you transfer your shares, what you're doing is you personally are selling your shares to the investor. And that investor's money is actually going to your personal bank account. And then you have to pay capital gains tax on the gain that you've just made on the sale of your shares, and the money actually doesn't go to the company, it actually went to you. So it's just an incorrect way to do it. So you don't want to generally be transferring your shares unless it's a more sophisticated transaction. But if it's a brand new company and you're doing your capital raise for the first time, normally you're not transferring shares, normally you're issuing new shares. And when you're bringing in a new shareholder, the documents that you normally have is a constitution, a shareholders agreement, and a subscription agreement or an application form. Now, the company constitution is essentially saying, these are the general rules on how to run a board meeting, what shareholders can vote on. It's more of a procedural document outlining the procedures, whereas a shareholders agreement normally sets out the particulars, like who can appoint a director, who can remove a director, how many directors do you need at a meeting to hold a board meeting? How many votes do you need at a board meeting to pass certain decisions? How many votes do you need at a shareholders meeting to pass certain decisions? If you want to sell your whole business, for instance, you can have what's called a drag along clause, which is 75% of the shareholders want to sell the business. Well, you can now force the other 25% of the shareholders to also sell. And that way you can sell the whole business and not get stuck being unable to sell your whole business. And then the other one is a dispute resolution clause. That's probably the most important. If people are disgruntled and a shareholder gets in an argument with the directors of the company, the only option is the Supreme Court of your relevant state. Unless you have a shareholders agreement, then in that case, you can sue under contract, and you can also sue, or you can also go and have a dispute resolution where you lock yourselves in a room for 8 hours trying to nut out a deal. So shareholders agreement is really, really important. And in that document, you can also put founders' rights. So you can give you rights that even though you might fall below 50% shareholding, you still have a lot of power. So for instance, under the Corporations Act, if you fall below 50%, well, shareholders get to vote who becomes a director, and the shareholders can vote, 51% of the shareholders can vote who becomes the director of the business. Now, if you have a shareholders agreement, you can say, as a founder, you always have a right to be a director. It doesn't matter if you only have 15% shares in the business. And so in that circumstance, that's what's called a founder's rights, where you might fall below 50% shareholding, but you still have a right to appoint a director. So it's really, really important to have a shareholders agreement, and your investors are going to generally expect one as well. Now, if you're doing crowdfunding, sometimes they don't use shareholders agreements, but they often take clauses that are in a shareholders agreement and put it into a constitution. The other document is a subscription agreement. That's where the investor says, I'm going to buy $100,000 worth of shares in your business, and you, as the company, make certain warranties, and possibly you as a founder also make certain warranties, such as the company doesn't have any debts, the company doesn't owe any large money to anybody, it's not being sued, it owns the intellectual property, it doesn't have any outstanding convertible notes or options, it's complied with the relevant laws, so on, so that the investor has certain promises from the company before they invest the money. And if one of those warranties were breached, then they can either sue for getting their money back, or you might have to top them up extra shares, or the founder might have to transfer their shares to the investor. And there's different ways that you can draft a subscription agreement. Sometimes people just offer an application form. That is more often than not used in public companies where they don't give any warranties at all, because you can do your own due diligence by looking up the ASIC records or the ASX records of all their financial reports and things like that. So the company doesn't give any warranties at all. It's just, you sign this document, you get shares. Whereas when it's a private company, your financials aren't disclosed. Sometimes people don't want to do the due diligence that they should. And so they want just warranties instead of you promising what you're saying is true. And so normally it's a subscription agreement as opposed to an application form. Now, I've already gone through what the Constitution says. Another thing is looking at if you're going to have a different class of shares. So oftentimes investors will want preference shares. And for doing that, you actually need to amend your Constitution. And normally you include an extra schedule in the agreement saying you're going to get preference shares, and this is what preference shares mean. I've had a couple disputes and a couple litigation matters where I've had people that have invested into a company and they were promised they're going to get M-class shares. And it turns out when we did an ASIC extract, they had A-class shares. Now, that sounds great. Instead of getting M-class, they got A-class. And but I asked my client, I said, well, what did M-class shares mean when you thought at the time of you investing? And he said, I don't know, I never checked. And I said, so why do you care that you've got A-class shares instead of M-class shares? Because you don't even know what you were getting. So if you're actually an investor, you want to look at what class of shares you're getting and what does that mean? An M-class share might mean no dividends, no votes. An A-class share might mean preference shares. You don't know, and where it dictates that, it's all in the Constitution. Now, a lot of VCs are looking to get preference shares, and generally speaking, in Australia, a preference share is they get certain voting rights normally. They also get the right to get topped up. So this is anti-dilution down round terms. So if you value your business at $1 million now, and your investor invests $100,000 for 10% of the business, and then later on you go and raise capital at an $800,000 valuation, then your investor can top themselves up as if they invested at an $800,000 valuation as opposed to the $1 million valuation, because they have an anti-dilution down round provision in their preference shares. And then they also get liquidation preference, which is normally that if the company's liquidated and all the creditors have been paid out and all the employees and liquidators have been paid out, and if there's money left over, then the investor gets their initial investment back before anyone else, any other shareholder gets their money. Now, I have a video on LawPath's YouTube channel on preference shares, and I also have a YouTube video on founders' rights. So if you want to hear more about those two things, just go to LawPath's YouTube channel and look that up. Now, shareholders agreement, again, I've talked about the founders' rights. I've talked about what's normally in a shareholders agreement, and that's something that you're going to need to look at. Now, if you are a subscriber to LawPath, we have a standard term sheet, which I can explain what that is in a moment, constitution, shareholders agreement, subscription agreement as well. And if you want to look at what is the process for actually issuing shares and how do I actually do it, have a look at the subscription agreement, go to the completion clause, I think it's around clause 5, and it says what the process is. So the investor is going to pay their money, you're going to issue them a share certificate, you're going to update your register of shareholders, showing them as a shareholder, you're going to update ASIC, you might appoint them as a director if they have the right to do so under the subscription agreement, things like that. So it outlines the whole process of what you do and how do you actually complete the transaction in issuing shares. And I've already talked about the subscription agreement versus an application form. And again, application forms are generally mostly used for public companies, or if you're doing crowdfunding. Now, one of the things that's interesting is debt instruments are becoming very interesting. The lenders are starting to become really interesting as well in how they're actually lending money. So one company is FundSquire, again, not to give a plug, but they do a lot of startup, high growth tech company lending. So they will say, okay, well, you have an annualized revenue of X, and because you have that annualized revenue of X through a subscription model, and you have $900,000 coming in this year, we will buy that subscription off of you, and we will then give you $900,000 in advance and charge you interest on that amount before you even got the money in. And that's kind of like a trade finance package, but that's something that's quite interesting. Another one is looking at R&D funding. So you get around 43.5% or 43.5 cents on the dollar for every dollar that you invest into research and development. So if you are doing a tech platform and you're developing something that's new, then you can possibly apply for an R&D grant if you can prove that you have developed new information and get money back from the government. It's not just a credit, it's actually money, cash money from the government to help fund. And there's funders out there like FundSquire again that goes and they will say, well, we can see what you're developing. We know you're going to get that money in soon. We will lend you more money right now to build your platform faster, and then we'll take the money that's coming back from the government and when it comes in. And I'll just say I am FundSquire does have a connection with me, so there is, I guess, a conflict there. So I just want to disclose that. But that's just one example of companies out there that do that kind of raising, and the debt instruments are just becoming very new and interesting. And what ends up being right for you, it depends on what stage you're at. And I'm sure, hopefully, a lot of people have a lot of questions. That's what we're here to do, answer your questions, and that's about it. So I'll pass you back over to Ryan, and then I'll come back to you with your questions.
Thank you so much for that, Damon, and very comprehensive take on the capital raising process and documents. So just to segue into how LawPath can help, we have a number of agreements on our platform that will be valuable for this process. So one of them is the simple agreement for future equity, the safe one that is on the platform as well. So just a bit about LawPath. We find that around 80% of individuals and 87% of small to medium businesses find it difficult to access legal services that they need. They find it expensive, complicated, and it's a convoluted process for them. So that's why we aim to make things simple with our essentials plan and our legal documents library. So as mentioned in the beginning, we do have a contract management system on the left-hand side, which is our 380 templates mixed with e-signature and adding team members into your accounts. Now you can also white label the documents with your company branding and logos. And again, it's an end-to-end solution for the legal documents from creation to signature and storage. Now, secondly, in the middle, around a personalized workflows. Now, we do have 7 workflows we've got going right now around setting up a family trust, employing a new employee, a contractor, collecting a debt, registering a trademark, and the like. There's a few extras there. So they do walk you through the full process of what you're looking to do and directly link you to those documents as well. And then lastly, booking in legal consultations. So if you'd love to speak with Damon or Sam or one of our expert lawyers on a business and commercial topic, then you can receive on-demand legal advice through the platform, booking it in very simply with our calendar link as well. So just to give a summary of our plans. So we've got 2 main advice plans. Firstly is the legal advice plan, which is getting unlimited 30-minute course with our lawyers each month. And you're able to, again, get this on-demand legal advice. So whether it's a proactive matter you're looking to undertake, or maybe it's a more reactive matter, you can speak to lawyers within 1 to 2 business days most times. We do have live chat with lawyers. So this is a new feature we've rolled out where if you have a simple question that doesn't need to be in depth, you can always just chat with the lawyers back and forth and get an answer pretty quickly. We do offer a contract review up to 4 pages. So if there's a number of documents you wanted to get reviewed or select pages of capital raising documents, you can do so. And then obviously discounted fixed price quotes on contract drafting. So if you do require additional work that falls outside the scope of the 4-page limit or an additional document, for example, a shareholders agreement, which is quite long, you can receive a discounted quote on that. Just one thing on the legal advice plan, we've now introduced video calls with our accounting calls and our lawyer calls. So if you want to go face-to-face on our website with your lawyers during the consultation, you can now do that as well. And then on the right-hand side with the accounting advice plan, it is everything in the legal advice plan and the documents as well, but it does include unlimited 30-minute calls with our chartered accountants. So you can speak to them through phone or video call. And this plan does involve ASIC and ATO agent service. So if you do require company changes, such as Damon mentioned, you might need to change your registered office address, change your directorship, etc. with ASIC, then we can do that as your appointed ASIC agent. Now, on the legal advice plan, we do have an accelerator program. So here are 6 topics that we aim to cover. Now, the purpose of this accelerator program is that if you want to attack things from a reactive standpoint, like things have come up or you need to get a document reviewed by a lawyer in a quick manner, you can do that on the platform. But from a proactive standpoint, we aim to do a complete holistic legal health check. So around these 6 topics, as you can see, the lawyers can sit down with you and review your business structure, protecting your brand and your IP, employment agreements and policies, supplier and commercial agreements, privacy and insurance policies, and then lastly, getting ready for capital raising. So particularly if you are in the capital raising process right now, it is important, as Damon mentioned, to get your intellectual property sorted through agreements with vendors, if you're working with them, or contractors, subcontractors, volunteers even. You want to protect and maintain your IP at all times, and then reviewing your business structure to ensure that if you're going to raise capital or this is something you've got in the pipeline, that you're doing things correct from day one. So this is a complimentary package that we're offering on the legal advice plan right now, and it's something that we've just rolled out with phenomenal results so far. Now, just lastly on these plans, they are deductible at 120% on your tax return. So there was a ATO decision in the budget on this, and it's on their website as well for some information, but it means that any money you spend with us on our subscription services can be tax deductible at 120%. So here is a bit of a fact sheet on how much you can claim back. And if you do want some more information on this, then I'm more than happy to send it out to you as well. So today's exclusive webinar offer for everyone on the webinar here today is 40% off our legal advice plan. So this works out to be around $72 per month. Normally, as you'll see on our website, it's $120 a month, and that is paid upfront. But again, to celebrate Black Friday coming into season next week, we're offering 40% off this plan. So again, it's a phenomenal offer. If you'd like to jump on the legal advice plan, get access to documentation and contract review, speak to Damon about the full capital raising process. But even if you're not looking to actively raise capital, even if it's not in the next few months, but something you're pipelining for the future, would strongly recommend you jump on the legal advice plan to receive the accelerator benefits on that program and to do a complete holistic check. Because again, if you haven't protected your intellectual property or your contracts are not correct, the longer you leave it, the worse it gets and the more expensive it is to change those things as well. So if you'd like to take advantage of our offer today, please comment yes into the chat below or the Q&A box, and one of our members of the sales team will be in touch with you this afternoon. Now, if you are a customer of LawPath on a lower tiered plan or an older deal or a trial plan, then you can still key in yes, and we'll be happy to explore your options and go through it with you as well. So now I'll pass it back to Damon for some Q&A as well. And again, any last questions or queries, pop them here and we'll take it from there.
Thank you very much, Ryan. All right, so can you outline options as an investment method? Options, yeah, they're not used that often in startup world, but I can explain what they are. So what happens is that the investor will normally pay a very nominal amount for an option to be able to buy shares at a later date at a fixed amount. So let's say, for instance, someone pays you $2,000 for the option to buy 10 shares at the fixed price of $1 per share for the next 2 years. So they watch the company, they monitor the company, and then in maybe 16 months from now, they say, okay, I want to exercise my option to buy shares in your business based on the fixed price that was 16 months ago. So there is certain circumstances where an investor might say, I am going to give you $100,000 now, and I want the option to put in another 100,000 in the next 12 months at the same price. And so you will then grant them an option under an option agreement that says, okay, well, the 100,000 you're putting now in is locked in. We've given you those shares, and we give you the option to buy the other $100,000 worth of shares at the same price, even though the value of our business might have gone up. So that's generally how options work from an investment perspective. Now, convertible notes count for early stage. When they convert, when do SAFE count as investment? When does the SAFE count as the investment? You probably have to talk to an accountant regarding that. I don't know the answer to that. So the interesting thing, accountants and lawyers might have different views on how a convertible note and how a SAFE is actually dealt with. So from an accounting perspective, convertible note is deemed a liability on the books for a company. And it's a liability because the investor has a right to get the money back. So therefore, it's a kind of considered as a debt. From a legal perspective, there's been some interesting leading cases on this area when the HIA or HIH collapsed many, many years ago, where the court said that It's not an actual debt until the investor seeks the recouping of the money by issuing a redemption notice. And so if it's not a debt, then what is it? It's what I would call a contingent liability. It sits somewhere between a debt and equity, whereas a safe is clearly an investment and it's clearly for shares. And so where does it sit and when does that investment happen? I can't give you an answer to that. You probably got to talk to the accountant when it comes to that, because that's the tax aspect of it for an accountant to answer. In setting up a company, should one do a shareholders agreement first and then register the company with ASIC, or should you register the company with the shareholders agreement to follow? So normally what will happen is you'll get a shareholders agreement in place. It won't be executed yet. It will be agreed upon by everybody. You just do an email with your co-founders. You say, all right, does everybody agree to sign this shareholders agreement? And they say, yes. So, okay, well, we'll sign this within 7 days after we incorporate the company, get everybody to say yes. You then incorporate your company, you enter the ASIC details or the ACN into the document, and then you sign it off. You can't sign it before the company exists because you're not a shareholder. So you normally get it going, get it ready, and then make sure that everybody knows that when they're going to be getting the shares, they're going to be subject to the shareholders agreement that they all agree to sign once the company is incorporated. Can't. I've heard about dilution of shares when new shares are issued when funding is received. How does one protect against this? Generally speaking, everybody's going to get diluted. It's the whole story is you get a smaller piece of a bigger pie. If you have clauses that say that I never get diluted, you basically killed your business already. No one's going to want to invest in your business. The reason for that is that if you bring in external investors and they put money in, every time moving forward, everybody gets diluted down. Because let's say you have 100 shares, you issue another 100 shares. So let's say you have 100 shares, you have the 100 shares, you issue another 100 shares to an investor, you now have 100 out of 200. So you now have gone from 100% shareholding to 50% shareholder. If you had non-dilutable shares, there's no way for you to take in investment because you can only have 100% and you always have 100%. But let's say you have shares that you've given yourself some preference shares that says that I always maintain 5% of the business no matter what. The problem with that is most investors will just reject it, or at least any sophisticated investor, because as you put more money into the company, if your shares don't get diluted down, it means everybody else's gets diluted down at a higher rate, which means they're essentially paying for your shares. So it's very rare. You might have been seen in movies and stuff, but non-dilution shares where you just don't get diluted is very, very rare. The only situation that you would see that is that it might be that a preference shareholder, a sophisticated investor or VC might say that I don't get diluted down unless you raise at a higher value than this existing raise, or I don't get diluted down unless, there's certain conditions, but very rare that you actually have anti-dilution shares that just never dilute. The slides and the recording will be both on YouTube, so you can just access that, which should be in the next day or two. In relation to R&D funding, just talking about R&D funding, most of this is accountants that do it, not lawyers. So will the purchase made still be tax deductible will the purchase made for R&D funding still be tax deductible? Will the gained income be considered income in the business? So in relation to the first question, I'm not exactly sure. I think the main concept, what I was trying to express is that if you are developing something new, one, you might be eligible for R&D tax incentive. Two, make sure you keep a timesheet and records of exactly what you're doing and have detailed records, and talk to your accountant, because they're the ones that make those applications and they have nothing to do with lawyers, unfortunately. So yeah, those questions, talk to an accountant about it. And on the legal advice plan, if you get the legal advice and accounting plan, you can talk to one of the accountants on the plan about that exact question. They can probably answer it for you. What do I need to get from an external developer for registering IP? Is there a template that I can ask an external developer for? So normally you should. So one of the major things that people have as a startup is the biggest issue is hiring a software developer. They go and they hire somebody, the developer promises them the world, and then when it comes time to deliver, they underperform, over budget, or very, very much delayed. So I highly recommend you get a software development agreement. Again, LawPath templates, it's in the library in the LawPath platform. Software development agreement basically says that you're going to agree on the scope of works, the functionality, break it down into milestones. When they deliver certain milestones, you pay it, and there's certain due dates, and you slowly go down and they finally deliver you the final product on budget and on time. And if they don't do it on time, then there could be liquidated damages or a right for you to terminate, things like that. So the software development agreement will normally say who owns the intellectual property. The standard generally is a threefold leveled intellectual property clause. It says that you might be building a financial services product and you've hired that developer because they've done it before. So the developer owns any technology that they already own, which is called the background IP or the developer IP. And anything new that they develop on top of it, or anything new they develop for you, is owned by you. So the developer can't just go and sell the exact same thing to somebody else, so that you're possibly first to market and you own all the code that they developed for you. And anything that you give to the developer, you own. But in terms of the background IP that the developer has built upon, they license that to you forever. So that's normally what a three-tier IP clause looks like. And most VCs understand that there's certain background stuff, there's certain open source code that you just don't own, but it's what you've done on top of it to manipulate it so that it developed what you have now is what you actually own, is the stuff that's on top of that open source code, or that stuff that's on top of what the original developer gave you. The second thing is making sure you have a license to use what the developer is giving you and building on top of forever. So it's a unrestricted license. So it's perpetual, irrevocable, royalty-free, transferable, sub-licensable, worldwide license to use, develop, modify, vary, adapt, commercialize, exploit, blah, 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 blah. The other way is if you haven't got a contract with someone and you've already developed it, then you can use an IP assignment deed that's going backwards, where you can get someone to sign. It's a 2-page document. It says that anything that they've developed for you, they're now assigning it and transferring it to you, so you own it. So those are the two documents generally of what you want. If it's going backwards, IP assignment deed, again, in the LawPath library, LawPath platform, or software development agreement, also in the LawPath library. What are some of the most common mistakes you've seen startups make in fundraising? So that's interesting. There's a lot of mistakes which startups make, and that's, I'll just reiterate these very quickly. One is not having a shareholders agreement for co-founders. So 3 people go into business, you all are given 33% of the shares in the business, someone quits, you can't take that 33% back. You're now stuck with one shareholder holding 33% of the business and has only worked in the business for a month. So you should have vesting conditions which says If anyone's getting shares on the anticipation of them working in your business, providing services in the future, all those shares should be subject to vesting conditions, which means that they have to earn their shares month on month over time so that they're not just getting something for free. In terms of fundraising, I think it's more bending over backwards for everything that the investor asks for. So a lot of times the investor wants to appoint a director, check, you give them a directorship. They want certain critical business decisions can't be made without their approval, check, you give that to them. Preference shares, you can't issue shares or you can't do certain things without their approval, and they also get all these other rights, check, you give that to them. A lot of that is the cookie cutter, and a lot of times you really need to be saying, no, I'm not just going to give you these. So, and if I am going to give it these, at least you as the founder should get identical rights at the very least. So that's some of the things that we normally find in the biggest mistakes. And also the warranties, you got to be very, very careful about the warranties. A lot of times says if there's a breach of warranty, the investors can just sue you and get all their money back. But it might just be that they want to change their mind. So they just come up with a random warranty that they know that you've breached, but it's not really significant. And then they're just going to claim all their money back. You might want to, you can detail a liability clause, and you can say, you know, you can only get back the liability amount of what that breach of warranty was, or that claimable amount for that warranty. Or you might say, well, we won't give you your money back, but we'll buy back your shares, or something along those lines. So there's different ways to work out a subscription agreement, but the main thing is don't just give an investor everything that they ask for. Because we have fundraisers who say, we'll take, or advisors that will take 5% of your business, you give it to them, and you've given them all these powers, and they didn't really invest very much in your business, and you're stuck with them for life. So you got to be very careful who you're giving a directorship to. And if you are giving a directorship to, it should always be so long as they hold X percentage of the business. So you can say, okay, well, right now you're coming in, you're going to hold 20% of the business. Great. We will give you a directorship in the business for so long as you hold at least 15% of the business. But if we get bigger investors come in, everybody gets diluted down, you drop below the 15%, you lose your directorship. So that's just something else to consider. How do I get my subscription service 100% deductible, tax deductible for my clients? I will get Ryan to send you a message about that. And then Murray has a question: should a shareholders agreement contain share vesting agreement? If you've already issued shares to the directors, can a vesting agreement be added later if the directors hold? So essentially what you're asking is, you've already issued shares. If everybody agrees, can you just now make them subject to vesting conditions? The answer is yes. Now, I normally like having the vesting conditions built into the shareholders agreement, as opposed to having a separate vesting agreement. That's because a shareholders agreement signed by all shareholders, seen by all shareholders, and all shareholders have the ability to enforce the vesting conditions. Whereas if you just do a side deal between the founders in the company, maybe the only way to enforce that agreement is to get the company to actually sue one of the founders, or to exercise rights. And it's going to be very difficult when a founder might be 50% director or 50% shareholder. The other thing, it's very messy to have is a separate contract, because the other shareholders aren't a party to it. So ideally, what you want to do is you want to create a shareholders agreement, and it's called reverse vesting. So you can say, as at the date of this agreement, all the shares become vesting. Or you can say, as at the date of this agreement, 25% of the shares are not subject to vesting. The other 25 or the other 75% are. But normally, if you're doing it like to clean up your accounts or clean up the agreements, it's normally a shareholder's deed, which is, and that's just a little bit of an explanation, is an agreement is an offer and acceptance consideration. So I'm giving up something for something. So giving up my time for shares, and a meeting of the minds, you understand what you're agreeing to. A deed is an offer and acceptance, of meeting of the minds, but it doesn't necessarily have to have consideration. So the problem with you, the fact that you've already issued shares to someone and then you're imposing vesting conditions on them in the future, there's actually no benefit to that shareholder agreeing to now making their shares subject to vesting conditions, because they're not giving up anything or receiving anything because they already have all the shares. So why would they now agree to it? But if you change it into a deed, then you don't have to have that benefit that exists when you do an agreement. So if you're going to do it, probably do it as a shareholder's deed, and it's just slightly changing the words in the agreement and the execution clause. We got a lot here. So the other one is do you have a plan where you book a single 30-minute or 60-minute call at a given rate without a subscription? Absolutely. So you can sign up to a free account with LawPath. If you sign up for a free account, you then get access to what's called the marketplace, where you can post your job of what you want. I want to have a telephone conversation about capital raising for 30 minutes or 60 minutes with a lawyer, explain the process, blah, blah, blah. That then gets assessed by the marketplace team, and then they then allocate it to a lawyer to give you a fixed quote. You can specifically ask for me as well. You can log in, create a free account, and then post your saying, I want to have a 30-minute or 60-minute call with Damon on this process. And then the marketplace team will see that and they'll automatically allocate it to you. And then I'll give a quote. The way that we work in terms of hourly rates and things like that, we got to determine whether 30 minutes or 60 minutes are necessary. Generally speaking, though, my charge out rate as a private practice lawyer is $5.50 an hour, but via LawPath Legal, we try to cater to LawPath clients, whether you're on the freemium account, essentials, LawPath Legal, legal advice plan. So we give discounted rates to startups. So you can probably anticipate getting maybe 20 to 30% discount. And then for people on the legal advice plan, you get a lot bigger discount, more like 40 or 50% discount to the standard rates. And then the legal advice plan is unlimited phone calls with the lawyer. So if one of the shareholders, sorry, I think I just lost that. If one of shareholders is also one of the software developers, you still need a software development agreement. Absolutely. So if you're giving shares to someone in exchange for developing your platform, the same thing should be, they still should be on vesting conditions. Generally, it should be, we are giving you shares because you're going to develop this for us. And your shares are on vesting conditions, possibly based on you hitting certain milestones. You're going to deliver this and we'll issue shares, and we're going to deliver that, you're going to issue shares, or subject to you working this many hours per week or whatever it is, but you still need a software development agreement because it's normally a separate company that's doing the development. Generally, and if it's not a separate company, so if it's just an individual and you're saying, I'm going to get this individual develop this software for me and I'm going to give him shares in exchange, that's fine, him or her. But one of the things that you want to consider is put them on vesting conditions. And if it's an external party that's saying, look, normally we charge 100 grand to develop this, but we're going to charge you discounted rates and we're going to charge you 70 grand, but on the condition that you give us shares in the business, that's fine. But those shares should be tied to that software development agreement so that they only get those shares as long as they deliver what they've promised for the price they promised and so on. I think that's about it. We have a lot of questions. I'm not going to be able to get through all of them. I think we're up for time. So I'll pass it over to Ryan. Thank you very much. And if you do have those questions, you can sign up to the legal advice plan, sign up for free, go onto the marketplace and ask for a quote to talk to me or one of the other lawyers. Thanks very much.
Thank you so much, Damon. Fantastic presentation. And thank you for everyone's engagement today and asking all these questions. Now, there's a ton of questions that we couldn't get to today, but these are perfect for the legal advice plan. So again, I'll put our offer up here just to really reiterate the value of what Damon said. The marketplace does provide quotations on a fixed price basis for work needing to be done. So if you've got a one-off, then that's definitely an option. But with the legal advice plan and 40% off, it's around $72 a month paid annually for unlimited calls throughout the year on new topics. So especially if you're going through this capital raising process, again, it's a phenomenal no-brainer offer. Just one or two calls would be cheaper than going through a quotation, but it does depend on your circumstances. So again, thanks to everyone for your questions today. If there's any further final questions that need to be directed to myself or the LawPath team, please key them in below and I'll be more than happy to pass it on. We will look into getting some slides and a recording of this webinar uploaded to our YouTube channel where you'll find all our past recordings as well. And again, if there's nothing else, I'll leave it up here and just launch a feedback poll to gain a bit of feedback on how you found today's webinar and what we can improve for future webinars. But we do run webinars like this every week. We'll be holding a small business one on Thursday as well, which will be sent an email on, and then future webinars in the coming weeks. So thank you to everyone for your time and attending today's webinar.